Welcome to the Bradley J. Show. We're going to talk about the Karen Reed trial, which is yay! It's back. It's something to do, something to think about, at the expense of the town there, or the state, I guess, and the expense of Karen Reed, big time. We have Michael Coyne, dean of the Massachusetts School of Law, and there's been a hiatus, and so it's all my fault.
No.
We should have been doing this more. My brother Phil, he's like, "Where's Dean Coyne?" So. I have questions, and there are things going on. There are hearings, stuff we need to know about, especially if you're a Karen Reed watcher. And I guess the best way to start would be to ask you, in general terms, what are the issues in play here as we lead up to an April 1st, I guess, potential trial date? What are these hearings about? What are the things that are in question?
Well, what the parties are fighting about right now is the various issues concerning discovery and what we call motions in limine. Motions in limine are brought in advance of trial to get pretrial rulings on the admissibility or the exclusion of evidence. And so a lot of the fights right now are dealing with whether witnesses can testify, whether there's been the proper disclosures concerning those witnesses, and whether there's the most pressing issue right now is whether there have been ethical lapses by the defense counsel. Defense counsel says there have been ethical lapses by the prosecution as well. But the pressing concern that came up this week and will be addressed again next week is whether the Reed's attorneys have failed to properly provide the information to the prosecution with respect to the ARCA, the accident reconstruction experts who testified during the first trial and are anticipated to be testifying during the second trial as well.
And so the beef is that, hey, you should have told us these guys were paid because that affects their credibility. And they argue that, you know, they went to great lengths to argue this and that, and kind of a roundabout way that, you know, we kind of, you should have known, and we kind of told you, and etc. And what is your take on what's happened so far in their efforts to get out of this jam?
Well, I'm not sure that they were entirely successful. You know, to point fingers and blame the other side, it's not us, it's them. When the court has specific questions with respect to representations counsel made at sidebar. Sidebar is where outside the jury's hearing, the lawyers make representations to the court with respect to witnesses and potential pieces of evidence. And we don't want the jury to hear it because it could influence them. But normally, the stenographer takes that down, and it's not even released publicly in a case like this, not until after the fact, because again, you don't want to poison the jury pool either. So there were representations made at sidebar there by Attorney Jackson that these witnesses were not hired or paid for, that they weren't prepped. You know, the judge specifically asked in court, for those that remember the trial itself, so you mean to tell me you're calling 3 witnesses who you've never spoken to before? And the answer was yes, in essence, Your Honor, that's correct. But see, that defies logic. It defies credibility. Almost like one of the cardinal rules of trial lawyer is don't ask a question you don't know the answer to. And now a woman's on trial for her life. And that's what we're looking at here. The second-degree murder charges carries with it a 15 to 20-year sentence to life. So, I mean, this is not we don't get much more serious than that in criminal matters. And you're going to put them on the stand without knowing exactly what they're going to testify to. That's his problem, is that's why she was so incredulous at the time, and many trial lawyers were incredulous that he would make such a representation. As it turns out, that representation isn't true.
I see. So you wouldn't ever put somebody on the stand you hadn't talked to first?
You shouldn't. I mean, you know, we even have it's an old school expression for it, horse shedding the witness. You prepare the witness for both the direct examination and the cross-examination. You know, it's very different than the stuff you see on TV with surprises at trial.
Yeah.
Well, we should know exactly what's likely to unfold. There's always going to be some bumps in the road and surprises, but you want to be very careful that you don't open a door that you realize that door should have stayed shut. You don't want to ask a question that ends up killing you because you didn't either prep the witness or you don't know the answer to that question. And so it becomes a dangerous game if you don't. And it would be highly unusual, especially for such key witnesses as these, to not have been prepped in some fashion with the counsel and with the expectation of this is what you're likely looking at for cross-examination.
A reminder, we're with Dean Michael Coyne of the Massachusetts School of Law talking about the Karen Reed case. So these ARCA people they had already made their report as part of a separate investigation. So if you'd read the report, do you still need to talk to them?
Oh, sure. Okay. You want to know, because you want to know what I should stay away from, for instance.
Yeah.
Where and how far can you go down the line with this? What do you expect that they will attack you on with respect to where your report is soft or where your opinion is soft? You want to have that exchange so that you can properly prepare the direct exam for it and hopefully stay away, and also know where to object on the cross-examination. So, expert witnesses are always, almost always going to require payment, oftentimes significant payment.
Yeah, I heard it was like 20 grand for these people or something like that.
There was 28 grand that they paid them in July for travel and trial prep. And it appears the federal government paid them for the initial evaluation of the issue as well. And so we don't know what those numbers were, but you can expect that it's in the tens of thousands of dollars at least. Accident reconstruction experts oftentimes are going to run you somewhere between north of $10,000 in all likelihood.
By the way, why are feds involved at all?
Well, that's another really interesting question with the case. They were investigating the investigators. And it's highly unusual for the federal government to involve itself in pending state court matters. Now, it appears that they are no longer investigating it. Your former colleague, Dan Ray, had the new U.S. attorney on the air the other night, and she said that they do speak to local law enforcement officials, and at least it appears that there are sources within local law enforcement that are saying they've been told the investigation is over. And so what they were looking for is flaws in the investigation, whether they're not just flaws, but criminal activity, for instance, that might support her conspiracy argument or her being seen as a scapegoat. And now with the prosecution likely closed, or the investigation likely closed, I should say, what it means is that the state court case will go forward likely in April, but depending on what she does with the various motions before her, it may be further delayed at this point.
I hope you don't have any pressing issues, because I have a lot of questions. So is it your sense that the new U.S. attorney brought this to a close because they were simply done, or because they are part of the new administration and they just don't have the will to move forward with something like that?
I think it's the former. Again, start from the standpoint that it was highly unusual for them to involve themselves in it at all, to really convene a grand jury and take testimony from various witnesses. But that was done over a couple of years ago now. That's when it began. And if you can't uncover criminal activity within that time, then maybe it is time to move on. And put those resources to better use.
Right.
We do know there are criminal activities that the U.S. Attorney's Office has an ample caseload already. They don't have to go looking for additional ones, especially where the evidence doesn't appear to indicate that they're going to be able to bring federal charges.
Okay, back to the thing we were talking about before. Are you surprised that the defense would be fuzzy on whether or not they had spoken to ARCA? Is that surprising? Why? The risk is so high.
The risk is so high, but it is and it isn't, think about this, Bradley. If we had, in fact, got a not guilty verdict on those 3 charges,
Right.
so that she goes free, this never would have been uncovered.
Uh-huh.
Because double jeopardy would preclude her from being retried again. No one would have gone further with the representations made that these were independent investigators and not compensated by the defendant. No one ever would have looked really at that whatsoever. And so it was, if in fact they did it, it was a gamble that they could get away with it if in fact they got the not guilty verdict that most of us expected, because we thought that the case was not tried as effectively as it could have been. And so why do it? Well, you're gambling if in fact it was intentional.
So they took a shot and they got busted.
Well, but even the defendant says, well, they were forgetful. They didn't remember these earlier emails, and they really didn't engage in prep. And part of that is Clinton, the old Bill Clinton's. It depends on what is. There certainly is a level of preparation here that they engaged in, and perhaps, in fairness to their position, not like one would engage in if I had commissioned their work and then were anticipating that I was putting them on the stand. Your expert, one you hired to do the report and done all that, we're going to sit down for a couple of days maybe to get ready for trial and cross-examination.
Mm-hmm. Okay, so what are the remedies here? What remedies can the court impose? A, ARCA people can't testify in the next trial. B, Jackson gets disbarred. C, Jackson can't be part of the new trial. What is your best guess?
I think C is more likely here based on the present state of the record. You're an out-of-state attorney. You are a guest to that court. You are admitted what we call pro hoc vice for the occasion. You have to dot your I's and cross your T's, and like a good house guest, don't leave your underwear on the floor and keep your room clean. It doesn't appear that they adhered to the standard I would expect that I would comply with when I've been admitted pro hoc vice around the country. And so I would not be surprised. He is going to be seriously admonished at the minimum, and she may in fact remove him from the defense team, leave the other attorneys intact so that if she gets mostly her choice of counsel. But I do expect that there will be some disciplinary action because she believes, and the evidence supports it, that he played fast and loose with the rules on disclosure under Rule 14 and the rule that we as advocates have to speak with candor to the court, to be able to not try to be disingenuous and not try to mislead the court, but be forthcoming as we make representations to the court, to the jury, and the prosecution. And specifically, I think she believes that representations made directly to her in response to her questions were not accurate. And there's evidence to support that.
Okay. Then there's an attempt to prevent this new trial, say, on the basis that the judge didn't do everything she could do to prevent a mistrial, and that the jury had come to a conclusion on some of the counts, and there's only that he had a very short time. It's up to them to object, and they only had a very short time to object, like a minute or something crazy like that. A very short time. Can you talk about that and how you think that'll pan out?
Sure, but well, first of all, let's put it in a bit of perspective. The jury had been out for 5 days at that point. They had returned a couple notes which would indicate that they were seriously torn. When you're awaiting a verdict like that, what the options are. Either they're going to come back with a guilty or not guilty, or they're going to be hung. As time dragged on here, it was clear, I think, to most of us who were carefully observing the trial that she was likely going to obtain a not guilty verdict from the jury. And I think the lawyers themselves likely thought that. As it drags on to day 4 and 5, you have to start to get concerned that either they're going to bring back a guilty on one of the counts, or they reach a compromise verdict to say, okay, we can't agree on all of them, but is there one we can? Let's find her guilty on X, Y, or Z. And both Yannetti and Jackson and Little all had to be thinking that the option now, day 5, might well be that they're going to compromise on a guilty verdict. And that would be that means even on the lowest count, there is a mandatory sentence provision.
So they may have wanted a mistrial, is what you're saying.
Exactly. At day 5, it is a tactical decision. They very well could be a tactical decision. Take my mistrial, declare victory, and hope that they never prosecute the case again. And that's not unreasonable. And especially, as our Supreme Court looked at it in looking at whether this double jeopardy bars the retrial, and whether there was a mistake by Judge Coyne in declaring the mistrial initially, a unanimous Massachusetts Supreme Judicial Court said, no, there was no verdict read in open court. The jury did not reach a unanimous verdict. That was publicly stated and recorded. And therefore, double jeopardy doesn't bar a retrial here under these circumstances. Double jeopardy only applies when there's been a verdict of not guilty, and they didn't return, as Massachusetts law requires, a verdict in open court that is unanimous by the jury under the circumstances. So
interesting.
Yeah.
So it's looking like we're headed for trial.
Yes, but next week they're going to try one last Hail Mary in federal court arguing double jeopardy. Since double jeopardy is a constitutional right, they've now chosen to take that issue to the federal district court down here in Boston. But I don't see that has much hope either, simply because our Supreme Judicial Court was very thoughtful. His decision is a solid one, and it's based on what our law is here, but also based on what the double jeopardy law is under the U.S. Constitution as well.
Okay, so say we do have a new trial. Will Trooper Proctor be able to testify? Will another jury hear the stuff that he texted and said?
Well, that's a great question, and it's still up in the air. His disciplinary action will proceed. I guess it'll be this month now when we're talking about March, and that should be the final hearing. So they will likely terminate him, suspend him. They'll discipline him in some fashion. Now, what poses an interesting question is, well, let's suppose, the case goes forward in April. If you're the prosecution, do you want to put him on the stand? Do you need to put him on the stand? Because everyone who saw that cross-examination was just horrible. The things he said, there's no way to justify it. They're incredibly unprofessional and crude. And it puts the Commonwealth's case in a very bad light.
But if you're the defense, can't you call him just to show bias?
You're the defense, and you can call him if the prosecution doesn't. It would be unusual for the prosecution not to call him. And in fact, we have a missing witness instruction in Massachusetts, which says if you have control over a witness and don't call him, there's a presumption that the testimony would have been bad. But you know what? This testimony is going to be bad. There's no way to make this look good. And so maybe they choose not to call him, even if the court says, well, I'm going to give the missing witness instruction. But if in fact they are, then that changes the dynamic a little bit about calling him. But I would not be surprised if the Commonwealth decides to cover, assuming they can, matters that he was involved with other witnesses. And if the defendant ultimately wants to call Proctor, then let them. And so it's an interesting question as to how it'll play out. Strategically, I don't know the answer yet. And I think it will in part depend on what that disciplinary action that he's facing and should be announced shortly will be.
If I were the boss, I'd be interested to distance my police force from a person like Trooper Proctor, but it doesn't seem to be that will. Is that because of the police union, or?
No, I think there is that will. I think they're taking their time with it. I can't believe, the governor's weighed in on it. Just about everyone has weighed in on this. I can't believe that they would think that this is a good look for the state police if he's kept on in some fashion. This was his actions were pretty outrageous.
Yeah, and not only
and
his actions, some of the stuff he said, I believe, was to a supervisor.
Supervisors, plural. There are multiple supervisors.
And they didn't do
on
anything. And they didn't say, you're suspended, Trooper Proctor. So aren't they on the hook too? And isn't the whole gang of them rotten?
Well, I wouldn't say the whole gang of them are rotten. I know a lot of good law enforcement.
I mean, in that town.
Well, it's not town. Those are state police.
Oh, sorry. State police. Wow.
So,
I mean, let's face it. That trial was so huge and watched by everybody over and over that it had to color the perception of
there's no
hundreds
doubt.
of thousands of people of the state police. And then when you're getting pulled over, you're thinking that.
Yes,
that's what you're thinking in your head.
There's no doubt it has tarnished the image of our state police. But with that said, I think a lot of folks in law enforcement, I have friends who are police chiefs, that they're looking at this as a teaching moment for all their officers to say,
right,
from now on, we got to step up our game a lot more and make sure that all of our actions are above reproach, because there's so many things that went wrong here. It's not just the text messages, it's the involvement of these folks who have a relationship with some of the witnesses and the like. It is a bad look. And then the collection of evidence and the preservation of evidence. There's so many bad looks here that you feel, and I expect there will be some serious disciplinary action here before we're done.
So I want to make it clear that I am a pro-police person. I like police. I worked in the emergency room and was tight with the police that would bring, people in and out of the emergency room all the time. And friends, I go shooting with police friends. I dig the police. And that's why I was particularly concerned about how bad Trooper Proctor made everything look.
I don't think there's any doubt about that. And I think a lot of us have similar thoughts, is that we're not police bashers. This is intolerable what took place here. And it becomes even worse when you think about it. This was the death of a Boston police officer, one of their own. You would think that if this is the manner they treat a death of one of their own, what would they do for one of us who they don't know from Adam, and have a talk show where they talk about things that aren't always as kind to law enforcement.
So they didn't have to retry this. Why is there the will to retry it? Where's the pressure come from?
It's the death of a Boston police officer.
I see.
If you remember, about a year before this, there was a death of a Weymouth police officer. The first trial was a hung jury because it was an insanity defense case. They retried him relatively quickly after that, and he was convicted. They believe that there is strong evidence that supports criminal action by the defendant here. I don't know whether it really, and I don't believe it ever has been, is going to warrant a second-degree murder conviction. But driving under the influence, serious bodily injury, that's a likely charge under these circumstances that certainly juries would find some evidence to support, and may find enough this time around to convict even.
Next, I saw a thing where Karen Reed went one-on-one with some reporter somewhere in a car.
Go ahead.
Is she doing herself any favor doing that? And isn't that a little bit like taking the witness stand?
Well, and it's interesting because now the new prosecutor, Hank Brennan, has asked for the tapes from a lot of these interviews. She did it with Dateline. She did it with some of the local reporters a couple different times. And normally, the advice most lawyers would give under the circumstances is keep your mouth shut, right? When you find yourself in a hole, stop digging.
Yeah.
And that's not what she's done here at all. She has used the media to get her message out, use people on social media to perpetuate not just the message, but even sort of strategy issues and the like. And it's not a good idea when her words then can ultimately be admitted in court. And I do think this time we may very well see some of the interviews, whether it's
Yeah.
the first Dateline or the second, or the interviews with some of the local reporters she's given, that could come back to haunt her, because they can be used at trial, and I would not be surprised if they are.
You're going to make a mistake.
Yes.
And it's I suppose she figured she needed the money.
Or to be able to influence potential jurors with some of this information. The eyeballs on this case are far and wide. It's not just limited to Massachusetts anymore.
I feel like she had maximized her sympathy, and to go and talk one-on-one would only dilute that. It did for me. I thought, yeah, okay, geez, she shouldn't have.
I don't. It's as a general matter, we tell people, and especially what becomes problematic is with younger people, because they're used to putting so much information in text messages and on social media and Instagram and all the rest, that you just shut down. Don't say anything to anyone, because all of this stuff can and will likely be used in court at this point.
A problem for you as a lawyer is, a lot of times they're going to have made statements way before they get to you.
Oh, sure.
So it's too late. They're going to have said dumb stuff to their friends.
Well, and the other part of it here is, maybe because some of these are post representation, sometimes clients don't listen to us, right? The lawyers may well be telling her, keep your mouth shut, and she just can't or won't. So, but you're right. Usually, think of a simple car accident these days. The likelihood is the people start texting, taking pictures, and sending them immediately right away to whoever. All of that becomes critical evidence in the case that ultimately can then be used against them.
Okay. How much, who pays the bill for the prosecution? How does that break down? Is it?
We pay. We pay. The tax dollars pay.
Right.
But it's a county prosecution.
Okay.
County dollars now are mostly funded through the Massachusetts taxpayer.
I see. So everybody in the state pays.
Yep.
Okay. And there's no way Karen Reed can come close to paying her bill ever. Why are the lawyers working for her?
Well, there's been a lot of fundraising. A lot. Like they're online, and they have various raffles and the like where they're trying to raise money. And so a lot of people have felt strongly that she is being scapegoated here. And therefore they have contributed to her defense. I think they see that if you could do this to her, this could happen to us. So people feel very strongly about her case. A number of people, obviously, many people feel just as strongly about justice for John O'Keefe,
Right.
and with respect to the prosecution's bringing the case against Karen Reed. But yes, there's been a lot of fundraising on it. The lawyers, first time around, my understanding was Jackson and Yannetti each made around $250,000. No one needs to have a ham and bean supper for these guys, because there's still a lot of money being made. And the fundraising has been absolutely significant with respect to the public donations to fund lawyers and the experts. It's a very expensive case when you start to think about all the time that has to be spent on it.
Okay. Just going back to one of the facts of the case that bothers me is, and correct me if I'm wrong, none of the investigators went into the house where the body was found. That's completely weird to me. Because you could, it was said that he never went in, correct?
Well, correct. No one, and that's why.
And what if you found, his jacket there inside, or a footprint of his shoe? That seems like willful, not doing your job.
No one ever said that he went in that house. No, not that morning, not at trial. Not a single witness testified at trial, in a 2-month-long trial, that he ever set foot in the house. That's the actual testimony. No
Right.
one that morning, including Karen Reed or the other witnesses who were out
Okay.
there and had been with him at the bar earlier, said he went in the house. Would it have been better police work to go to the door and ask if he came in and could you come in the house? Probably. But some people argue, well, you have probable cause to search at that point. And I'm not so sure you do, based on that there's a body, near the side of the road, where you're in your front or adjacent to your front yard. I'm not so sure that's enough to go get a search warrant. I don't know.
Plus, they just didn't have, to use the word will again, probably didn't have the will to say, maybe we can get a search warrant. But yeah, it's like, what?
Remember, the testimony all is she's telling everyone or multiple people, I hit him. I hit him.
I know.
So why?
So there's that. Right?
Why would you? How far wide are you going to cast a net for the killer?
Okay, but
when the woman in there is saying, I did it.
She shouldn't have said that, but she could have been worried sick. Oh my God, I bet I hit him, like that.
Sure.
Bad luck saying that, of course.
Sure. Oh yeah, and that there is an argument to support that if your partner is dead, you would feel guilt over we shouldn't have been out drinking as late as we did. I shouldn't have been drinking. We should have driven right home. There's a million things you'd have remorse about, and feel responsible for. There's no doubt, but I'm not so sure you'd go as far to say I hit him.
All right, yeah,
and that's the testimony.
I know. Okay, how come nobody brought up, hey, they were stupefyingly drunk driving? Did she ever get charged with drunk driving?
Yeah, well, the driving and she didn't get charged directly with driving under the influence. She did get charged with, in essence, driving under the influence causing death. So there is a charge there, but she does not face a straight charge of driving under the influence, which, the medical testimony at trial clearly indicated she was, at the time, at midnight or so, she would have had virtually a blackout drunk level of of alcohol in her blood, approaching 0.3 is my recollection, which would be extraordinarily high. And by the way, so did John have a very high level of alcohol in his blood.
He drove. Did he drive? He drove too, right?
He did not drive.
He did not drive. Okay, good.
She was driving, good. But that may have helped contribute to him being incapacitated at some point out in the snow.
Wow. Well, I feel a little guilty being so interested in the case. It's a kind of sick, morbid thing to watch the case, but I am, and so are many. And it is an interesting window into the workings of the law. There are so many people covering this who are lawyers doing podcasts and stuff that it's pretty instructive.
Oh yeah. Well, and it is a good thing that people understand a little more closely how these serious consequences occur as a result of drinking and driving. And that's what this case is at the core. If you go back and really take a look at it, it's what's drilled into us from middle school on: drinking, driving, deadly consequences. And at least from the prosecution standpoint, that is what this case is that, bad things happen when we mix alcohol and 2-ton vehicles in the snow. And that's something that we should expect, that there's potential for very serious consequences as there were here, which is sad, because he was a really good man, taking care of his nieces and nephew. The tragedy that had befallen that family earlier with another sibling, and he was a police officer. He was there to protect us, and now at a very young age he's lost. So it's a tragic case.
So what do you think is going to happen? You think this? I mean,
yeah.
Maybe this. I mean, when you couch it that way, it's like maybe she does get found guilty this time.
Well, remember last time at the point before they declared the mistrial, there are juror reports that they were at 9-3 guilty on the driving under the influence with causing death.
Yeah.
So if the government, and I expect they will, try a much more streamlined case focusing on those issues, frankly, I would forget the second-degree murder charge.
Yeah.
But if they focused on those issues, I do think that that with the right jury and the right presentation of the case, you very well may see a guilty verdict come back, and then you're going to see the defendant face a significant period of time in prison.
Yeah.
And
I feel like a lot of jury sympathy came from Proctor. And if he doesn't show up, and if they focus on what a good guy the officer was, and then and keep the charge narrow, like you say, then there's a pretty good chance she'll be found guilty.
I think it's still probably a toss-up simply because of the issues you raise. You know, Proctor's a wild card that we really don't know how that will develop this time, even though we're a month away to trial. What's the best way to present or not present that information? Because it's a huge problem for the Commonwealth, his involvement, period, in the case. So the question is, I mean, whether you call him or not, we're going to hear his name a fair amount in the case at any rate. So dealing with that issue, it's not an insurmountable obstacle, but it's not a small one either. So
is it 15 to 20? Is that the penalty if you found
second-degree murder? Second-degree murder is life in prison, and the judge can say that would carry, instead of life in prison, life in prison, but should be eligible for parole in 15 years or 20 years. The judge can decide what that would be. I think it would be the lower charge, but the lower amount, 15 years. But I don't see a conviction on the second-degree murder. I do see a conviction on the DUI homicide, and that can carry a sentence with it of up to 5 years.
Wow. Boy, yeah, thank you for your time. By the Menendez brothers for parole. Did they have their parole hearing yet?
No, my wife and I were just saying that last night. That's another one that a lot of people are very interested in and have very strong feelings on as well.
Me too. Maybe we can do that next time.
Sure. Love to.
Unless some Karen Reed things pops up first.
Oh, there'll be Karen Reed things popping up all month at this point. Next week, there's 3 different days of hearing. There's a federal court hearing on her habeas petition from now till, until, maybe if she issues a sanction decision on Jackson, suspending his pro hoc vice admission, that will slow things down because there'll be appeals and the like. But if that's not done, then between now and April, every week there'll be some item that comes up and raises its head because jury impanelment is going to start the end of the month.
Wow. Okay. It's something to do.
It's plenty to do
to keep me occupied. Dean Coyne, Massachusetts School of Law. Are you on vacation now? No, break.
A couple more weeks before our spring break. So we're working hard here.
Okay, good. Well, thank you very much. And we'll speak to you much sooner than we did. There won't be the big gap.
I hope not. That's on both our ends. We have to work a little harder at that.
All right.
Okay, good.
Okay, thanks. And everybody share this. That helps the channel, and like it and subscribe and all that. Bye now. All right. And but don't you go away. We'll be